Um, I'm so sorry about that, everyone. So I'm going to do a very brief overview of what exactly property guardianship is. I'm sure many of you know, but some of you who've dialed in this morning may be slightly new to this concept. We've got a quotation at the top of the page, which is taken from something called a headline report that was commissioned by the Department for Housing, Communities, Levelling Up, or whatever it's currently called, because I think it changes its name frequently these days. But they published this report that I'm going to touch on in a little bit more detail in a moment, which provides that first bullet point. So a form of private accommodation in which occupants live, but where they also have an explicit role in providing security for a property that would otherwise be empty. And so what we're talking about when we talk about guardianship is a situation where a landowner, either a freeholder or a long leaseholder, has a building which has fallen vacant. And rather than incur the significant expense of hiring a private security company that would provide watchmen and patrols and so on, they turn instead to a property guardianship arrangement, where people are invited to actually live in the building in order to deter trespassers, vandals, squatters, and so on. Now, the guardians are not licensed security persons. They don't provide shifts or patrols or anything like that. They're simply there. They occupy it as their only or principal residence. But generally, as we're going to talk about, they enjoy less security of tenure. They're often mere licensees. Because, of course, the landowner will want to be able to recover vacant possession of the building very quickly, if and when they need it back. Now, sometimes it's just the case that a building has fallen vacant and the owner is looking for a new tenant. It seems that more often this situation arises where a building is going to be redeveloped and it's taking a couple of years to get plans in place. And so these buildings are sometimes occupied for quite a long period of time. We're not talking weeks or months, it could potentially be years, in which potentially quite large numbers of people live in these buildings. It's a feature of this arrangement that the landowners essentially never, or it's very rare to hear of them actually trying to set up this sort of operation themselves. Instead, they turn to the services of what we call guardianship companies, who will come in and take over management of the building. Often will carry out any adaptations that are needed, such as fittings and kitchens or additional bathrooms. I will then find the individual guardians and contract with them and kind of deal with them in their occupation of the building. And again, it's a feature that we tend not to see just one or two people living in a building in order to secure it. The companies will often fill the building to whatever its sort of reasonable capacity is. So, for example, one person might live in each room, for example, of an office which has a large number of rooms on each floor. So this is an innovation from the Netherlands. It started there about 20 years ago. It subsequently expanded into the UK. And one of the interesting features about this is it's not just private landowners who are using these services. It seems like there's very large numbers of public sector landowners getting involved as well. My experience is particularly local authorities and various bodies that are emanations of the NHS. So NHS trusts, ICBs, special health boards, things like that. Both categories of public authorities that often tend to have very large property portfolios. So what sort of numbers of buildings and people are we talking about? I'm not going to read out all these statistics. These are taken from the headline report, which I mentioned a moment ago. The report is very clear in emphasising that there are no statistics or there's no national monitoring or any sort of reliable hard data which says with any certainty exactly what numbers of people are involved. And so the report portrays itself as very open about saying it's really only trying to give a flavour of what's happening. But two clear themes emerge from the evidence I've extracted and given you here. One of which is that this is not a London phenomenon. The research carried out in 2021 and 22 found that at least 41% of local authorities across England and Wales were aware of there being some guardians in their area. And on one day, they did a snapshot search of a single website, spareroom.com, which is used to advertise properties for let, and found guardianship rooms available in 95 local authority districts, 80 of which were outside London. So this is a national practice. The other theme which clearly emerges is that we think this is growing. So in 2017, there was a sort of estimated 5,000 to 7,000 guardians nationally. But more recently, they've estimated that there are between 20 to 40 companies operating as guardianship companies at any one time. It's difficult to keep track of that because there's some evidence that some of these companies tend to come and go, and perhaps if they find themselves in financial difficulties or get involved in difficult litigation, the companies sometimes go into liquidation and then reopen under a new guise with the same directors and shareholders. There's at least one documented practice of that. And we're going to be talking today in some detail about a group of companies called Global Guardians, and their evidence before the first tier tribunal last year, which is mentioned in the judgments as public record, is that at the time, a year ago, it then had 700 properties on its books and had dealt with about 5,000 guardians. And that's just one of somewhere between 20 and 40 companies. So we think it's growing, and we think actually quite large numbers of people in terms of occupants of these properties are involved. So who are they? I thought I'd draw your attention to this Channel 4 sitcom, which is a guardianship comedy set in a disused hospital, came out a few years ago, and involves Phoebe Waller-Bridge, who is famous for another show called Fleabag. Follows 6 or 7 characters who are sort of thrown together because they live in this shared building. And I think it's interesting to look at the sorts of people that these characters are. So we've got a young couple who are living in guardianship accommodation so they can save up the deposit to buy a house. We've got a gentleman a bit older who's going through a divorce. His finances are in disarray, and so he needs to save some money. And we've got, for example, the lady with the red hair who's an artist who rents a big room and uses it as a studio. And it seems that all of those characters are people who frankly are quite middle class, are well educated, and are portrayed as having voluntarily chosen to live in this sort of accommodation because of the flexibility it offers them and the advantages in terms of cost and so on. But the headline report, and I should say that those sorts of people very much echo the vision of guardianship that I think some of the companies like to project when they're advertising their services or in their legal pleadings in cases they've been involved in. But the headline report shows a slightly more complex picture. The first bullet point here, the buzzwords that you can see will be financial insecurity, unaffordability of housing, few alternatives, low paid insecure employment. And it seems that quite a lot of the people living in these properties would tell you that they're there because they don't have any better options. I also thought it was very interesting that one company told researchers they had started working with a large homelessness charity during the pandemic. So by definition, anyone housed in guardianship accommodation under that route is quite likely to have some significant vulnerabilities. And then, of course, we have complaints about the conditions of these premises. It does seem clear from speaking to people who are involved in guardianship that some of the companies offer very well run, managed and maintained accommodation, but other companies not so much. And I think when we bear in mind, for example, that these buildings are often awaiting demolition or very significant redevelopment in circumstances where there isn't a great deal of incentive to invest in their condition because they're about to be torn down or whatever it is. And also, of course, when we're talking about the Housing Act 2004, it's very clear that we're talking about a situation where buildings are being used for purposes that they were not designed. So people residing in commercial offices, retail, etc. And we know, of course, that is, when it comes to HMOs, that's precisely the sort of accommodation that tends to be associated with greater health and safety risks. There is no law and policy on this, and I just thought it was worth flagging that point. A bit like Uber or Pimlico Plumbers, guardianship is one of these phenomenon that has developed in the last 10 or 20 years, which was not expressly anticipated by lawmakers when they drew up the Housing Act 2004, the Housing Acts that grant security of tenure to renters, and other legislation concerned with health and safety. And so quite a lot of the reason why there's been a lot of litigation in this area recently is while people try to work out to what extent it fits within the existing regulatory regimes. Central government, as far as I can see, has been fairly silent on this, save for this one quotation that I managed to find in the Property Guardians guidance, which came out earlier this year, which is actually a really excellent guidance that is aimed at people who might live as guardians or are considering becoming guardians, about their rights and things they may want to consider. And any of you who work with them, I would certainly point them towards it. But a very interesting throwaway paragraph, which is that the government does not endorse or encourage the use of property guardian schemes, which I thought was very interesting. And also, I just would flag with you, the London Assembly's Housing Committee looked into this in 2018, did quite a detailed report, and effectively highlighted the fact that this has been sort of overlooked or superseded existing legislation, which should be revised and updated. That call 4 years on has not been implemented. But anyone who does want to find out more about this, I'd certainly recommend that the government's headline report and the London Assembly report. So where are we so far in terms of litigation? I've listed here in one place, more or less, all of the decisions that we are aware of or that have been reported, which consider the issue of guardianship. The first category is what security of tenure do guardians have when they live in these buildings? There was a case back in 2018, Camelot Guardian Management and Coup. Camelot went into liquidation not very long afterwards, where Mr. Coup was found to be a mere licensee. More recently, that's been overtaken by the decision of the Court of Appeal in La Leyva, and Dean is going to get into the meat of that with you in a moment. When it comes to the Housing Act 2004, there's been quite a bit of litigation about whether or not properties occupied by large numbers of guardians are licensable as HMOs. The position we've sort of got to at the moment, and I'm just going to dwell on this for a second, so I think the kind of current state of play is clear. In Jimenez, the upper tribunal held that the property in that case was licensable as a HMO. And in Global Guardians Management in Hounslow, which was the case I was involved in, the president of the Lands Chamber effectively applied and agreed with Jimenez, but he also went on to find that the guardianship companies involved in the management of that building were liable to enforcement for the failure to license it as a HMO. The local authority had issued civil penalty notices against them for the criminal offence under Section 72, which were upheld, and there was also a rent repayment order made in favour of the guardians. Now, Global 100 and Global Guardians Management are part of the same group, and those are the two, they're sister companies with the same directors, and are still trading and quite a big company. Those are the two decisions we're going to get into in a bit more detail in the rest of the webinar. But I think it's worth just highlighting that Global 100 has been given permission to appeal to the Court of Appeal in Jimenez. It's not yet been listed, and Global Guardians Management still has a little bit more time to decide whether or not they'd like to apply for permission to appeal their decision. If they do and permission's granted, it seems likely that those two cases would go up together and be heard jointly by the Court of Appeal. So what's then interesting is 35 to 37 William Road at the bottom of that list. That is in fact the same premises involved in Jimenez. Jimenez was an application for a rent repayment order by the Guardians, but Camden, which was the local authority, also issued a civil penalty notice to Global 100. They appealed against that civil penalty notice, and the appeal was dismissed by the first tier tribunal on the 6th of July last year. We understand that Global 100 has also applied for permission to appeal that decision, but it's not yet been heard by the upper tribunal. So there is potentially a third case that might get wrapped in, and very much the same legal arguments have been raised in all three matters. Two other cases, just to make you briefly aware of. Cambridge Heath Road was another application for a rent repayment order at the first tier tribunal, which succeeded. The arguments that the property didn't need to be licensed because the guardians were mere licensees was dismissed, and that wasn't appealed. Russell Hill Road is another case that Dean is going to talk about a little bit later on. But that's an interesting case because the freeholder of the property there was a local authority. It was a building owned by Croydon. And the first tier tribunal held that the building was licensable as a HMO, but a rent repayment order couldn't be made against the respondent because he was a company director. So Kajowska and White upheld the finding about the company director at the upper tribunal, but didn't reconsider the issue of the freeholder's liability effectively to license. So there's some interesting issues come out of that Dean's going to address. I'm not going to spend much time talking about ratings or planning. We could have a whole other webinar on those two subjects, but I just wanted to make the audience aware there's a very interesting decision about Ludgate House, which confirms that for the purposes of ratings, the building is deemed to remain in commercial use and not to have switched into residential use for the purposes of ratings. So it's been suggested that that sits slightly at odds with decisions under the Housing Act 2004. But that is the only other kind of Court of Appeal decision on guardianship. On planning, I'm not aware of any reported decisions. It's entirely possible there have been decisions of hearings or inquiries which deal with guardianship issues. I would just say that we know that conversion to a HMO can be a material change of use, which might require planning consent. There are permitted development rights for Class C4 use, which is a HMO of up to 6 people. But those permitted development rights have been removed in quite a lot of individual local authority areas by way of Article 4 directions, including in a lot of London boroughs. So effectively that you will need planning permission to change a building into Class C4 use. Any HMO which involves more than 6 people would also need planning consent. So I think anyone attending today who sometimes advises freeholders who instruct guardianship companies might want to draw that to their attention, that if the building will be a HMO whilst it's in guardianship use, that there could be planning implications for that and potential enforcement action if the local authority had a problem with it. All right, so I'm going to hand over to Dean at this point, and I'll be back later.
Tara, thank you very much for that typically helpful and insightful introduction. I'm going to talk to you now about 2 particular issues that have arisen in recent times arising from property guardianship arrangements. First of all, concerning the security of tenure enjoyed, or rather not enjoyed, by those who occupy guarded properties. And secondly, whether guarded properties meet the sole use condition for the purposes of the housing in multiple occupation definition under section 254 of the Housing Act 2004. So dealing first with security of tenure, let's take a look at the case of Global 100 Limited and Leleva that Tara mentioned in her introduction. Now, for some time, there's been some controversy about the security of tenure enjoyed by property guardians in the premises they secure, but in respect of Global 100's guardians, at least, that controversy has now been resolved. The appeal in Global 100 Limited and Leleva raised several interesting issues, including the stringency of the test applied when a court considers in possession proceedings whether a defence to the claim is genuinely disputed on grounds that appear to be substantial. But for present purposes, the relevant issue concerned Mr. Leleva's security of tenure. Was she a guardian placed by Global 100 in a building previously used as NHS accommodation and offices, latterly, I believe, a tenant or a licensee? The essential facts as set out on the slide were these: that NHS Property Services Limited, who was the freehold owner of the Stamford Brooks Centre, a building, as I say, once used as accommodation for NHS staff and offices, entered into an agreement with Global Guardians Management Limited, by which GGM, as I'll refer to them, agreed to provide property guardian services to secure the building against trespassers, an arrangement that Tara has summarised in her introduction. And by that agreement, GGM assured NHS Property Services that, among other matters, it would be able to yield up the building with vacant possession when the agreement came to an end. And so to fulfil its obligations, GGM entered into an intercompany agreement with Global 100, giving essentially Global 100 the right to grant temporary non-exclusive licenses to property guardians who would then occupy and secure the building, and to G100, Global 100, a sufficient interest in the property to bring any claim to eject those guardians should they fail to leave. And then in turn, Global 100 entered into an agreement with Leleva and others, described as a temporary license to occupy the property. And I'll come back to the key features of that agreement momentarily. When Ms. Leleva and others then refused to vacate the property when required, Global 100 brought a claim to repossess it. And in defence of that claim, Ms. Leleva argued, among other various arguments, that her agreement with Global 100 had created a tenancy and not a license, and that insofar as the written agreement suggested otherwise, it was a sham. That matter went first in front of District Judge Parker in, I believe, Wandsworth County Court, who found that the claim was not genuinely disputed on grounds that appear to be substantial, and granted Global 100 possession of the premises. When His Honour Judge Luber QC, as he then was, allowed Le Laver's appeal against that order, Global 100 then appealed further to the Court of Appeal, and that's where the authoritative decision in Le Laver comes from. So on the issue with which we're concerned, that is security of tenure, the court held that Le Laver's agreement with Global 100 created a license, and that there was no real prospect of Mr. Le Laver demonstrating otherwise, or that the agreement was a sham. The lead judgment with which the other members of the court agreed was given by Lord Justice Lewison. And that's instructive, I would suggest, for its concise analysis, typically concise analysis, I should say, of the approach to construing agreements of this kind and classifying them correctly in law. So to summarise, the starting point is always to identify the parties' respective rights and obligations as laid out in the written agreement, to consider the circumstances in which that agreement was made, and only then to ask, by reference to those rights, those obligations and circumstances, what the appropriate classification of the agreement in law should be. In Mr. Le Laver's case, the following factors in particular pointed conclusively to the existence of a licence only. So first of all, the Guardian's lack of security of tenure was essential to the purpose and efficacy of the agreement, including GGM's obligation to yield up the property with vacant possession when the Guardian's services were no longer required. Secondly, the Guardians were not a self-selected group, as tenants usually are, but had been chosen by Global 100 to fulfil GDM's obligations to NHS Property Services Limited. Thirdly, then, under the agreements, Global 100 had the right to alter the location and extent of the Guardian's living space, a right which militated against any grant of exclusive possession, which really is the hallmark of a tenancy. Fourthly, then, the Guardians were required and indeed had agreed to share the building amicably with others chosen by Global 100, and had non-exclusive possession of the whole and not any particular part. It was held at paragraph 43. And then lastly, their situation was akin to that of service occupiers. Service occupiers, employees who generally occupy accommodation provided by their employer to better carry out their employment, who don't, as a matter of law, generally enjoy exclusive possession of premises. And I'll return to the analogy drawn with service occupiers very shortly. If we could pop to the next slide, Sarah, that would be great. Thank you very much. Let's first look at the approach to construing an agreement and deciding whether a particular agreement grants a tenancy or a license. So Lord Justice Lewison, in this case, applied Lord Templeman's well-known dicta in Street and Mountford, and cited the Supreme Court's approval of his own dicta in a case called Secret Hotels 2 Limited and HMRC, which, if I may respectfully say so, reflects my own practice of always trying to cite a case in which I was involved as authority in skeleton arguments that I draft. But please don't share that secret with anyone else. The dicta from Secret Hotels 2 Limited, in all these cases, the starting point is to identify the legal rights and obligations of the parties as a matter of contract before going on to classify them. Yeah, he then turned to, again, Lord Templeman's dicta in the well-known case of AG Securities and Vaughan, that as well as the terms of the agreement, the court may consider and should consider the circumstances in which that agreement was made. And you can see the citation that supports that proposition set out on the slide. Materially, in this case, those circumstances included the reason, really quite important in the labour, why the occupier was let into occupation in the first place. And the court noted, in addition, as pointed out at the bottom of the slide, that sole use would not necessarily be tantamount to exclusive occupation. Well, let's now return to this analogy drawn with service occupiers on the next slide. Lord Justice Lewison acknowledged that Thank you, Tara. Property guardians are not strictly employees of those providing guardian services to the owner, but noted that the law relating to service occupiers, in particular the proposition that they don't generally enjoy exclusive possession of the premises they occupy, had in fact already been applied to property guardians in the earlier case of Ludgate House Limited and Ricketts, which was a valuation case. In that respect, therefore, the case sets no new precedent because the proposition had already been applied to guardians, albeit in a slightly different context. In Laleva, the fact that it was necessary for the provision of the guardian services that Miss Laleva should occupy the property meant that she didn't enjoy exclusive possession of it. And so to the conclusion of the case, paragraph 48, on the proper interpretation of Miss Laleva's agreement, considered in light of the surrounding circumstances and the purpose of the agreement, the argument that it created a tenancy rather than a license had no real prospect of success. So what then is the significance of the Laleva judgment? Well, necessarily, I think we have to point out Laleva is a decision on its facts, based, as the last citation indicated, on the proper interpretation of her agreement, considered in light of the surrounding circumstances, the circumstances in which that agreement was made and the purpose of that agreement. So strictly, its conclusion will be determinative only where, as in the Global Guardians case in which Tara was involved, the facts and circumstances of any subsequent case are indistinguishable. Otherwise, it may be persuasive, but each case must necessarily be decided on its and assessed on its own facts. Nonetheless, it's right to point out that as the purpose and the circumstances of other such agreements are likely to be very similar, it's unlikely that a court or tribunal would be easily persuaded to a different conclusion about agreements that are essentially similar to those used in Laleva. And Laleva, at least, as the slide points out, now settles the proper classification of Global 100 seemingly standard term agreements. The argument that they create a tenancy rather than a license has, as matters stand, no real prospect of success. So let's turn now from security of tenure to the question of houses in multiple occupation. Do the buildings in which guardians reside and live, do they meet the definition of a house in multiple occupation under section 254 of the 2004 Act? And in that regard, more particularly, do they meet its sole use condition? So that issue has been controversial of late. And many of you will know that the sole use condition forms part of a number of tests by which a building may qualify as an HMO. And that includes the standard test, the self-contained flat test, and the converted building test under section 254. And it also applies in a modified form when a local authority chooses to make a declaration that a particular building is an HMO under section 255. But let's take a look at sections 254 and 260 first. So on this slide, I've given you the provisions of section 254.2, which enacts the standard test. That's the first of 5 conditions or circumstances in which a building will generally qualify as an HMO. And as you'll see, of the 6 criteria, A to F, the building must meet. The 4th, D, prescribes that the occupant's use of the building's living accommodation as their only or main residence must constitute the only use of that accommodation. And as I say, that criterion is modified, as we'll see later on, if the local housing authority wishes to declare a building to be an HMO. For present purposes, though, note that by section 260 in the right-hand column, a presumption applies that the sole use condition is met unless the contrary is shown. And that presumption was an important factor in subsequent litigation. The consequence of that provision and the presumption is that, of course, it shifts the burden of proof onto the person claiming that the condition is not met. So why are these provisions relevant? Well, let's take a look first at the case of Jimenez, which Tara mentioned in her introduction. This is the first of two recent cases in which the argument was made that the use of living accommodation as the guardian's only or main residence was not the only use of that accommodation, and that the buildings didn't therefore qualify as HMOs under the 2004 Act, whether for the purposes of licensing or otherwise. The cases raised other arguments, some of which Tara will cover shortly, but for the time being, let's focus on sole use. So the facts of Jimenez were, unsurprisingly perhaps, not dissimilar to those of La Leyva. GGM had agreed to provide property guardian services for Euston 1 Limited, which was the freeholder of the former Addison Lee building in Euston. It then granted Global 100 the right to grant licenses to various property guardians, and in turn Global 100 granted Jimenez and others a license to occupy offices in the building in order to secure them against trespassers. When the local housing authority, in this case Camden London Borough Council, so hat tip to Jack Kane and Paul Bernard if you're listening, when they inspected the building, they found it occupied as an unlicensed standard test HMO. And in due course, as a result of that, Jimenez and others applied to the First Tier Tribunal for rent repayment orders, alleging that Global 100 had committed an offence under section 72(1) of the 2004 Act, essentially for managing or having control of an unlicensed HMO. In defence of that allegation, Global 100's main argument was that the building was not an HMO because the sole use condition in section 2542D wasn't met. Jimenez and others, they argued, occupied it so as to provide the property guardian services that GGM had promised to Euston 1 Limited. An occupation of the building was simply a necessary means of fulfilling that obligation. Well, the First Tier Tribunal rejected that argument rather summarily, it has to be said, and made a rent repayment order. And so Global 100 pursued it on appeal to the upper tribunal. Like the First Tier Tribunal, however, in this case, the Deputy President Martin Roger QC, as he then was, now Casey, rejected that argument. He noted, among other matters, that under section 260, the sole use condition is presumed to be met unless the contrary is shown, and that the burden had been on Global 100 to show that the building was used other than as living accommodation. Just pause there for a moment to note that it's not, as I think is said in the judgment, the building itself to which the sole use condition applies, but the living accommodation within it, a point to which Mr. Justice Fancourt returns later in Tara's case, the Global Guardian's case. Significantly, the Deputy President, however, held that the statutory definition of an HMO and necessarily the sole use condition that it incorporates should, in his words, not be interpreted so narrowly as to frustrate the achievement of a statutory purpose. And as Tara referred to in the introduction to this webinar, one of the main purposes of Part 2 licensing and of the regulation of HMOs generally is to reduce or remove, where possible, the significant risk that multiple occupancy poses to the occupants of HMOs, including significant risk of fire. And they, no doubt, I would imagine, are dicta on which local housing authorities nationwide will surely place emphasis when the courts and tribunals are called upon to construe other parts of the 2004 Act, and in particular parts 2 and 3. The mainstay of the Deputy President's reasoning, however, was that Global 100's license agreements did not require or allow for more than one use of the living accommodation. In fact, the agreement expressly prohibited those who were living in the accommodation from providing security services per se. They were required to occupy the accommodation as their only or main residence, and importantly, they weren't allowed to do anything else but that. And so in the circumstances, the security that they provided was essentially a byproduct of their occupation of the premises and nothing more than that. And that was the conclusion that the Deputy President reached. And in addition to that, of course, he also held that the building itself didn't have more than one use, albeit it's the living accommodation to which the condition applies. So in the circumstances, therefore, the first tier tribunal had been right to find that the sole use condition was satisfied, and the building was an HMO. And as Tara and I were discussing just before we came on air, that conclusion, in our view, I think I'm right in speaking for both of us, has to be right in these particular circumstances, given that the only use to which the guardians could put that accommodation was to use it as their only or main residence. That brings us to Tara's case, in fact, to the Global Guardians case, in which Tara acted so successfully for Hounslow. Hats tip to Baljeet, if she is listening. This was a case in which Global Guardians Management Limited also sought to run the Jimenez sole use argument. As the essential facts of it are in many respects the same as those for the Laleva case, of which we've already looked, and Tara will be returning to them very shortly in any event, I'm not going to rehearse them here, save to note that as a result of the local housing authority, Hounslow in this case, finding that the Stamford Brook Centre was occupied as an unlicensed HMO, it penalised both Global Guardians Management Limited and Global 100 as persons controlling or managing the building, and their director under section 249A of the 2004 Act for an offence under section 72(1). And in addition, Ms. Laleva and others applied to the first tier tribunal for rent repayment orders. The first tier tribunal heard both that application and the appeals against the financial penalties together, and rejected the sole use argument advanced by the global companies, dismissing also their appeals and making rent repayment orders. So they duly appealed to the upper tribunal, and their appeal was heard in July by Mr. Justice Fancourt. Two main issues arose on the appeal. The first was the sole use argument. So was the guardian's use of the living accommodation as their only or main residence the only use of that accommodation? And then secondly, if so, were the global company's persons managing or having control of the building, point to which Tara is going to return very shortly. But on the first of those issues, sole use, the appellants essentially reserved their position for the Court of Appeal. They recognised sensibly, I would suggest, that they were going to struggle to persuade Mr. Justice Fancourt to find that the Deputy President had been clearly wrong in Jimenez. And I stress clearly wrong because that's a threshold they would have had to cross to persuade the upper tribunal to depart from one of its own decisions. So they put forward the same argument as was advanced in Jimenez, and for the same reasons then as were given by the Deputy President, Mr. Justice Fancourt rejected it, and those are reasons are set out on the slide. So what is the significance of the findings about sole use in Jimenez and Global Guardians? Well, very much that remains to be seen. As Tara pointed out, the upper tribunal granted Global 100 permission to appeal its decision in Jimenez to the Court of Appeal. Although, as noted at paragraph 41 of the Hounslow case, that's the Global Guardians case, that appeal has not yet been listed for hearing. In fact, as the slide points out at the moment, it doesn't actually appear in a search of the Court of Appeal's case tracker system, which is curious, but we assume that that appeal is still extant and merely awaits the possibility of the global companies appealing the recent decision in the Hounslow case. And I believe I'm right in saying they've got until about the end of this month to do so. So assuming either or both of those appeals proceed, the Court of Appeal will take a second look at this sole use argument in due course. For the time being, at least, Jimenez is likely authoritative as to the use made of buildings occupied, at least pursuant to Global 100's standard term licenses. One has to question, however, whether the outcome of Jimenez would not have been different if Global 100's license agreements had allowed for and indeed required the guardians to provide services other than simply using the building's living accommodation as their only or main residence. Well, possibly is the answer to that. It's not inconceivable in the circumstances, in light of those judgments, that guardianship companies nationwide will not perhaps now be taking steps to recast their standard term agreements and rearrange their affairs so as to make the sole use arguments at least a little bit more compelling. Time in that regard will surely tell. But note, and this is quite interesting, that the building status in Jimenez and Global Guardians needn't have been different, even if the sole use condition hadn't been met, provided that the Guardian's use of that living accommodation formed a significant use of it. So in that case, where it was not necessarily the sole use, but merely a significant use of it, the local housing authorities would have been empowered to declare the buildings to be HMOs under Section 255, taking advantage of the modified version of the use condition, requiring only significant as opposed to sole or exclusive use of the accommodation as the occupant's only or main residence. Under Section 260, the Guardian's use of that accommodation would be presumed met unless would be presumed to meet the significant use test, unless the contrary were proved, and the building would therefore be an HMO under Section 254(1)(d), so long as that declaration was in force. So query, what is the significance of these cases remains to be seen, but they do raise some really quite interesting issues, the Global Guardians case in particular, about control and management. And on that note, I hand back over to Tara.
Thanks, Dean. I mean, I think before we leave sole use, it does seem that as the law stands, unless or until there's a Court of Appeal decision to the contrary, it would certainly be advisable for property owners and or guardianship companies who were involved in these operations to give some careful thought to whether or not they should make a protective HMO license application. It's, you know, there's a real risk that if the license terms and conditions are somewhat similar to those used by Global Guardians, that it's an unlicensed HMO. And, you know, bear in mind that as soon as a license application is put in, there is an automatic immunity from any potential criminal liability for failure to license. So the license doesn't have to be granted, but the license application has to be made. And I do think that's certainly something that would require some careful thought, I think, if you are involved in the building run-up. Anyway, moving on to slightly maybe even thornier issues. So, you know, the sole use condition means a property is a HMO and probably needs a license. But then the next question is, well, who is responsible for complying with the licensing requirements? In this section, we're also going to cover a brief point about Schedule 14, which provides an exemption to HMO licensing requirements. But Dean's going to come back to that briefly at the end, and I'm going to cover managing and controlling before that. This is the glorious Stamford Book Centre. This is the building at the heart of all this litigation. And so this was the building occupied by Miss Laleva and 29 other guardians. There was 30 of them here in total, sharing 4 showers, not all of which worked allegedly all the time, and a small number of kitchens and bathrooms. So this was the building involved in Global 100 and Laleva, which dealt with security of tenure, and with Global Guardians management and Hounslow, which is the case I was involved in. So Dean kind of outlined the facts and the contractual relationships earlier, and I don't want to repeat what he has said, but I think it's quite important to revisit these relationships, because the statutory definitions of management and control, and this is relevant because the criminal offence for failing to license a HMO under Section 72 is committed by a person who is either a controller or a manager of the HMO. And the criminal offence of failing to comply with HMO management regulations, which stipulate the minimum standards of repair and maintenance and safety, that offence is committed by a manager who has failed to keep the property in line with the regulations. Those statutory definitions are principally, if not wholly, concerned with the income generated by the property. And to identify who is the person controlling or managing, you got to follow the money. It is all down to who collects the license fees, effectively, in this case, from guardians rather than rent. Who's collecting the income generated from the use of the premises? Are they contractually entitled to it? Or does the money pass through their hands on the way to the person who's contractually entitled to it, usually either as an agent or trustee? And so a quick recap of the relationships and contracts in in the Global Guardian's Stamford Brook situation. It's important to caveat this by saying that the nature of each of these contractual agreements was hotly contested by all sides. And if you read the judgments, you'll see that a great deal of the time and energy of the litigation, or of the courts and tribunals' times, was in making findings about what the nature of each of these agreements was, before the tribunal then went on to consider what the effect of that was for the purposes of Section 263. So at the top of the, sorry, and I should say what I'm about to tell you is based on the findings that have now been made by the upper tribunal. Those may yet be subject to appeal by the Court of Appeal, as we've said, but for the time being, this is our understanding of how this worked. So at the top of the pyramid, you have NHS Property Services Limited, a company that owned the freehold. Interestingly, that was a company that was owned or largely controlled by the Secretary of State for Health. And one of the grounds raised on that was that might have triggered a statutory exemption to HMO licensing, which Dean will talk about in a moment, Schedule 14. NHS Property Services contracted with Company 1, which was GGM, and GGM portrayed itself as offering a sort of a managing agency service. Now, normally in those situations, you, the property owner, will pay the agent to fulfill a service for you. The agreement worked the other way around in this case. GGM was paying NHS Property Services £600 per month for the privilege of using its building and effectively exploiting it for rental income comprised of the licence fees from guardians. And because of the circumstances of that agreement and the way in which it operated, which included things like GGM being able to exercise control over who entered the building, actually having permission to exclude NHS Property Services itself from the premises, had taken on responsibility for maintenance, repairs, and so on. The first tier tribunal and the upper tribunal both considered that that was actually a tenancy agreement between NHS Services and GGM, rather than some sort of agency operation. And that was a key finding for the purposes of management and control, as we'll see in a moment. So assume that GGM is actually a tenant of NHS Property Services here. GGM then entered into an intercompany agreement with Global 100, which permitted Global 100 to have sufficient access to the building in order to grant licenses to individual guardians. So it was G100 went away and identified, interviewed, accepted the individual occupants like Ms. Leva and others, and granted them their license agreements to occupy individual rooms of the premises. Global 100 granted those license agreements in its own name, and it collected the license fees from the guardians. So you had GGM paying NHS Property Services £600 per month for the use of the building. Global 100, when the property was full and all 30 rooms were occupied, Global 100 was collecting about £15,000 per month from the guardians. So you can see there was a very significant discrepancy in the two sums of money that were changing hands. Now, so we know that from the Leva and the Court of Appeal, we know that the guardians held residential license agreements with Global 100. The nature of the agreement between Global 100 and GGM was a slightly murkier idea. It seems that the upper tribunal was eventually satisfied that was a license agreement. So Global 100 was not a subtenant of GGM, and it was not GGM's managing agent. It was a licensee who was sort of given sufficient interest in the premises in order to deal with the guardians. We know from some of the evidence that was provided in the proceedings that at least some of the £15,000 a month in license fees was being passed by G100 back to GGM, who paid the utilities, council tax, and other bills at the premises. But despite many requests for disclosure, the companies did not provide details of so their internal financial arrangements. The FTT was not particularly impressed by that. But nonetheless, that was the position that the parties and council and the tribunal were left in, which is we knew that some of the money was sharing hands, but effectively there was no evidence to prove beyond reasonable doubt that GGM had any sort of contractual entitlement to get its share or all of the guardian license fees. And that becomes quite an important part of the analysis for management and control. So I'm going to deal with managing first. Just to remind you, section 2633 effectively opens three gateways, which would allow a tribunal or a court to find that a person is managing premises. First of all, there's gateway one is 1A is an owner or lessee. For the sake of completeness, I would add that an owner is anyone actually with a lease which has more than 3 years left to run. So it doesn't necessarily mean the freeholder, although it can include the freeholder. So gateway 1A is an owner or lessee who receives directly or through an agent or trustee, and note the words agent or trustee because they don't include licensee. There's a closed category of people who can transfer the money. The owner receives rents or other payments from the persons who are in occupation of parts of the premises in a HMO. So from, in this case, the guardians. Alternatively, you're a manager if you're an owner or lessee who would receive the rents or other payments, but for having entered into an arrangement with another person. And the key point here is that that person must not be themselves an owner or lessee of the premises. So we're not talking about a subtenant, we're talking about perhaps a manager, perhaps a letting agent, a trustee, or indeed perhaps a licensee. And the third gateway is that if rents from the occupants are received through another person as agent or trustee and then passed on to the owner or lessee at the top of the pyramid, that other person, namely the agent or trustee, is also a manager. So pausing there, you can see in the first bullet point I've outlined here, a manager is an owner, a lessee, or an agent or trustee who's receiving rents on behalf of the owner or lessee. Now, all three of those categories are people who get their hands on the money at some point. And clearly the statutory interpretation is that it is people who can actually access the income being generated from the premises will generally be the ones in a position to ensure that license conditions are complied with and management regulations are met and so on. Now, that definition did not apply to G100 because there's two lacunae as I've identified. Firstly, 2633 subsection 3 applies to agents or trustees, but not licensees. And so when you have someone in the middle of a chain who's a mere licensee rather than a tenant, they will not meet this definition. And so G100 could not be held liable under this limb. As for GGM, who was the tenant of the freeholder, well, they were not receiving payments from the HMO occupants because they were not receiving any money directly or contractually from the individual guardian occupants. And there was some evidence, as I said, that G100 was giving them some of the money, but not all of it. And the tribunal basically held that getting some of the money was not enough, that the way to interpret section 263, subsection 3B, is that 3A, is that all of the money needs to be going to the person who is the manager, to be contractually entitled to all of it. And again, because of the criminal standard of proof, there needs to be quite comprehensive evidence. It means the tribunal can be sure that they're getting all of the funds. But not to worry, because GGM, again, the tenant of the freeholder, was a person who was caught by section 2633B. So they are a person who would have received license fees for the guardians, but for the fact that they had gone away and entered into this intercompany agreement with G100. Now, it was very clear from the terms of the tenancy agreement between GGM and the freeholder that GGM was being given permission, but possibly also required, to make sure there were guardians occupying the premises to make sure the property was being kept safe. That was the purpose of the agreement. And so they would have been in breach of their own agreement had they not made sure that someone was living there. They didn't wriggle out of responsibility just because they had effectively subcontracted that responsibility out to G100. So you'll remember I pointed out that the arrangement must be with a person who's not an owner or lessee, and that was fine. G100 as a licensee. An interesting point that the tribunal made was it was relevant that GGM didn't actually have any direct relationship with the guardians itself. The tribunal sort of said, well, GGM would have been entitled to receive license fees, but they wouldn't actually have been the same license fees that G100 collected, because that was under different license agreements, and effectively said that the statutory purpose that must be achieved by part 2, which Dean's already talked about, was paramount here, and that any other more narrow interpretation of these provisions would undermine that purpose, because it would simply make it too easy for people to evade responsibility for HMO licensing by entering into these agreements with family members, with friends, with sister companies, who frankly might pass on most of the income to them, but would allow them to escape by removing their contractual link to the occupants. And the interesting thing about this was those were all the conclusions of the president of the tribunal, Mr. Justice Fancourt. But about 2 weeks before the decision was handed down in the Global Guardians case, the deputy president, Martin Roger KC, reached identical conclusions on different facts in a case called Cabo and Dazzotti. That wasn't cited to Mr. Justice Fancourt because the parties frankly were unaware that case was going on and hadn't seen the judgment yet at the time of the hearing. But that was to do with an ordinary HMO, a non-guardianship HMO, which was being run by a woman, her husband, and the husband's company. And again, it was a situation where it seemed quite clear that the woman who owned the freehold had sort of immunized herself contractually, but was clearly receiving income and still had a close connection to what was happening at the premises. And Martin Roger applied similar reasoning to the interpretation of the Act. We then go on to look at persons in control of the HMO, and this is the part of the Act that's principally concerned with rack rent and who is receiving the rack rent of the premises. Section 2631 offers two limbs to identify people having control. So the first limb is the person who receives the rack rent, either on his own account or as agent or trustee. And alternatively, they are a person who would receive the rack rent if the premises were let at a rack rent. And because rack rent is defined as at least 2/3 of the full net annual value of the premises, the second limb would seem to be engaged in circumstances where perhaps the property has been let for 50% of its market value instead of 66%. And the person is still getting the majority of the income from the premises, or they would have done if they'd let the property at a higher value. That definition is clearly meant to guard against situations in which somebody lets the property for just a little bit less money in order to escape liability. So in Global Guardians, interestingly enough, it was accepted by Global Guardians that rack rent, for the purposes of Section 2632, could be comprised of license fees. So there didn't need to be a tenancy in place. The rack rent could be paid by the guardians who were licensees offering money to G100. They did try to argue there was a distinction between the aggregate rack rent of the rent that was paid for, or the license fees paid for all the individual rooms, 30 rooms in this case, versus the rack rent that might be generated by the building as a whole if it was let under a single letting. And that argument was roundly rejected. It's previously been rejected in another case called Urban Lettings. And again, it was said that would very much undermine the purposes of the Act because it would allow too many people to escape from this definition. Another interesting finding by Mr. Justice Fancourt was he was satisfied there was sufficient evidence to show that £15,000 a month paid by the guardians was enough to be 2/3 of the net annual value of the premises. Global Guardians argued that there was no valuation evidence. There was nothing from an estate agent or otherwise to compare the rents or license fees being achieved at this building to others like it in the same area. And the tribunal effectively said that wasn't necessary. There was enough to infer on the criminal standard of proof that the commercial reality is that the guardianship companies exist to maximise profit, to fill the buildings to their capacity and achieve the best rents, the best license fees that they can on the market. There's no reason to think they would be letting it an undervalue. And also it was relevant that this was not traditional accommodation that would be let on an AST. It was a converted office building in the condition that it was in and being used in the way that it was, and it was never going to achieve the same sort of rents as a building in a very different sort of condition. So what did that mean for GGM and G100? Well, G100 was a person in control because it got all the money. It got £15,000 a month. It was contractually entitled to collect that money and to keep it. It was in control. It received the rack rent. But GGM was not in control because, again, although GGM seemed to be getting some of that money, it wasn't getting all of it. and it's not sufficient for G100 to pass on some of the money so it could be used to pay bills, etc. You need to be receiving the whole of the rack rent in your own right. And again, that echoes similar conclusions in Cabo and Dazzotti. So in Global Guardians, finally, the tribunal declined to consider if GGM was a person who would have received the rack rent. It said that second limb wasn't relevant or wasn't engaged if the premises in fact is let at a rack rent, which it found that it was. I would just leave that open as to say there's probably argument to be had about that, and there might be if this goes up on appeal as to whether or not that was right. But the court tribunal effectively said it just didn't need to determine the issue. But that could potentially be quite important in different cases on different facts if you're trying to make sure that somebody involved in the property does meet this definition. So that's it, and a final point from Dean before we take questions from everyone. Thank you very much.
Yes, I can see that we've passed 12 o'clock, so I'm going to deal with these final two slides as briefly as I can by telling you about the conundrum that's posed by some of the exceptions that we find to HMO status in Schedule 14 to the 2004 Act. So the status of a particular building and it's being accepted from HMO status under Schedule 14 was raised in the Global Guardians case, albeit before the first-tier tribunal only, and it may have consequences for local housing authorities. So as many of you will know, by Section 254, subsection 5, a building or part of a building is not an HMO for the purpose of licensing under Parts 2 or indeed Part 3 of the 2004 Act if it falls within a description of buildings that are listed in Schedule 14. And Schedule 14 enacts a limited range of exceptions which materially for present purposes include under paragraph 2 an exception for buildings that are controlled or managed by a public sector body. A public sector body is defined to include, as you might imagine, local housing authorities, and as was relevant in the global cases, a health service body within the meaning of Section 9 of the NHS Act 2006. And that was defined under Section 9 as essentially, where material, the Secretary of State. There are other health service bodies, but for the purposes of the global litigation, it was that particular description that was relevant. And before the first-tier tribunal, the global companies sought to argue that NHS Property Services Limited should be equated with the Secretary of State for the purposes of that exception to HMO status. Well, the first-tier tribunal rejected that argument, and sensibly, in my opinion, it wasn't pursued before the upper tribunal. But if we move to the last slide, Tara, in a guardianship case, what happens where the local housing authority or the local authority owns a building and engages property guardians to secure it? Is that building licensable as an HMO under Part 2, assuming it's otherwise occupied as an HMO, or is it accepted under Schedule 14 because the local authority still controls or manages it? Well, there's no authoritative case yet on point, and much may, and I stress may, depend on the nature of the agreement that the local authority makes with the guardian companies they engage. For example, whether they engage them as an agent, grant them a license, or grant them a tenancy. The first-tier tribunal did consider this issue in the 49 Russell Hill Road case, which Tara mentioned right at the start of this webinar, in which it found that Croydon Council had granted Camelot a tenancy of the property in question, and so was not a person having control of it or managing it. And that finding then wasn't challenged on appeal to the upper tribunal in Kozowski and White. But query respectfully, was that conclusion right? As far as control is concerned, the formula used by the 2004 Act for establishing control of a building has a long pedigree in public health and planning legislation, and was clearly borrowed deliberately, as far as I can see, from that and similar legislation when Parliament enacted the 2004 Act. And its long established authority under that legislation that more than one personal body, including superior landlords, can be in control of a property at any one time, provided, of course, they meet the control definition. And I refer in particular to the case of London Corporation and Cusack Smith, a 1955 case, which was cited, in fact, with approval by the upper tribunal in the case of Urban Lettings London and Haringey. So in short, unless the courts and tribunals adopt a similar approach to control under the 2004 Act, as was taken in Recusant and Jepson, which of course is going up to the Supreme Court, to the definition of a landlord under the 2016 Act, i.e. that is one that excludes superior landlords from its ambit, then local authorities may well find that buildings they've secured using guardian services are not licensable under Part 2 because they remain in control of them nonetheless. There's also a point, as Tara and I were discussing before we came on air this morning, about management in some of these arrangements where the guardians who occupy the property are not in occupation of the whole of it, but only occupy certain units of living accommodation. It may well be said that actually it is the main guardianship company that remains in occupation of the common parts, and insofar as it's then paying the local authority to do so and to provide that service, that the local authority is then receiving payments from those in occupation of the property, and therefore qualifies as a manager of the property, of that particular property. So there are issues that remain to be resolved here, and it may well be, as I say, that in circumstances where a local housing authority has engaged guardians to secure a property for it, that it will find that it's unable to claim that the property is a licensable HMO for the purposes of Part 2 or potentially for Part 3. So that brings us to the end of the webinar, slightly over time, for which apologies. So we have a very brief, short period in which we can take questions. Tara and I have endeavoured to answer some of them during the course of the webinar, so you'll have our answers in writing. And I'm wondering, in fact, whether there are any that remain that...
There is one interesting question from someone who's asked, effectively, wouldn't the application of Part 2 licensing requirements to guardianship effectively be financially incompatible with guardianship arrangements and offer a sort of a perverse disincentive to the operations of those arrangements? I mean, I think it's a good question. I think it probably remains to be seen. But, you know, at the end of the day, the cost of complying with the HMO regime is something that will be absorbed into the cost of license fees and passed on to guardians. And you might say, well, that's less than ideal in circumstances where we're all paying, you know, too much rent and cost of living and so on as things stand, particularly because these are people who need somewhere perhaps more low cost to live. I mean, at the same time, it's already happening within other HMOs which are not occupied by guardians, and yet somehow landlords manage to make quite a lot of profit out of HMOs anyway, and that's why we see so many of them. I think a point that I made to Dean earlier this morning, and I think it's worth repeating, is this: all that a guardianship company or a freeholder needs to do in order to evade liability or to comply with the regime is submit a license application. The license application doesn't actually have to be granted. And so particularly if a building is only going to be used for a few months, the local authority may not even yet have had a chance to issue the license or to process the application before the building is vacated again. It also means that at least the initial step of complying is not necessarily tremendously expensive. But I think the bigger point is this, that if a building is in good condition, is well managed and well run, and is already compliant with health and safety standards, then complying with the HMO management regulations shouldn't really cost all that much extra, shouldn't involve many more works being carried out to the premises. So for people who are responsible, landlords, agents, managers of these buildings, shouldn't pose a high threshold. If, however, companies are financially dependent upon exploiting conditions in buildings in very bad condition, overcrowding them with large numbers of guardians, and the cost of bringing the building up to standard would be prohibitive, one might think that maybe this shouldn't isn't a very good way of running your business, and isn't something that the government or local authority should tolerate. I think that's ultimately my view, but I do understand that the issue is complex, and it remains to be seen what effect it might have on the sector.
Yeah, I think it's also worth pointing out that in cases, in fact, in the global cases where they control numerous properties for the purposes of providing guardian services, it's not uncommon for local housing authorities to provide to offer a discount for multiple applications where multiple applications are required. And so, as Tara rightly points out, in these commercial, let's face it, commercial arrangements, that cost is very easily absorbed by the guardianship companies. So it really ought not to be inconsistent with or incompatible with the guardianship model.
Yeah, I mean, I'd also point out that, like, in Global Guardian's case, and I imagine any other sort of big guardianship operation, you know, they have their own in-house repairs teams. They are regularly fitting kitchens and fixing showers, and dealing with health and safety, fire requirements, and so on. So again, when you're already up and running at that scale, the cost of having to send someone around to deal with some repairs is lower, I think, perhaps, than if it's just a one-off operation.
Yeah, quite.
All right.
Right.
Well, unless there's any other burning questions, I was going to say, please do feel free to email myself and Dean with anything in follow-up. And I'm sorry if I've just interrupted you to say the thing he was about to say.
No, not at all. You said it. You said it instead of me. That's fine. But I think that probably does bring our webinar to an end, which means it only remains for us to say thank you very much for joining us.